right, good morning. We're on the record. If you could please state your appearances.
Hello, Your Honor. Bob Cercio, bar number 5247. With me is Mother Christy Bow.
All right, good morning, ma'am.
Good morning, Your Honor. Rebecca Fuller, bar number 9809, on behalf of Andrew Baptista.
Okay, good morning, sir. So I know you've had a chance to talk to each other. Have you had any resolutions at all?
A few minor ones.
Okay.
That's something at least, right? So we did agree that the parties should attend mediation to see if they're able to work anything out on their own.
Okay.
So we would like the FMC referral today. We did discuss also implementing the 30-30 rule for medical, since there wasn't a clear order in the Missouri order. So we would like to implement that as well. That was about the extent of the resolution.
We're also at adequate cause for a trial date.
I'm sorry?
We're also at adequate cause being met.
You'd like to set a trial date?
Yes.
Okay.
And then what we would be arguing for, although it's not going to seem like it's truncated, basically all of the nitpicky things that are before us, and we're going to be asking for some temporary orders from you today, whatever they are.
Okay. Whenever you're ready.
Thanks, Your Honor. So this is a case that emanates out of Missouri. It was a hotly contested paternity action, resulted in 2 orders. Those are summarized: joint legal custody, joint physical custody, and then a 250-mile rule. If mom moves within 250 miles, there would be a slight change to the visitation. On the second order in October of 16, the court granted mother joint physical custody until the child starts kindergarten. Kindergarten started about 2 weeks ago. And that's what brings us forward. We would like to continue the week-on, week-off that has been in effect for all of these months and not go to primary physical custody to father. That's the core of the thing. Oh, one more thing on the agreements is jurisdictionally that we have jurisdiction to go forward on all issues. So our essential relief, what we're looking for you today, is to return to the week-on, week-off visitation with exchanges at the school on Monday morning in order to keep conflict down to a minimum. The standard of law to apply, whether it's the Rivero best interest of the child factor or the Ellis versus Carucci, is now going to be a trial issue. So the changes in custody, that legal argument can go down the road a little bit. So let's talk about some of the events. One is that we have a fundamental need for civility. It is a rough exchange of words and text between the parties, language that I would like not to repeat in court, but it's as bad as it gets. So, and I think opposing counsel's okay with this. All communication should be through Our Family Wizard, except for emergency contact and Our Family Wizard with the text option, so that emails and text are treated equivalently in terms of the platforms that it hits on the phones.
And we are absolutely in agreement with that. I think it would be preferable.
On the 250-mile rule, why we think that is inadequate is that it's essentially a springing forward change in custody rather than a review of the facts on the ground. In Nevada, we deal more with due process considerations when we see the changes in this. So the Missouri order treats, if one parent's in Las Vegas, the other one could go to Goldfield, Tonopah, Caliente, Flagstaff, Arizona, even the Los Angeles Basin, and it's still the same order that we're under right now. And it would be impractical. What the Missouri order fails to address is what happens if they live about 5 minutes apart, which is the facts on the ground. Would the Missouri court have still made a primary physical custody leap at the or if it was okay for joint physical custody all the way from the initial orders until 2 weeks ago, why not continue that? And that's the conundrum that we're asking you to fix today. Other than the distance issue, there doesn't seem to be any reason in the Missouri order for a change. The court found there that they were both loving parents. Now, there were both positive and negative findings in those orders relating to the parents, but the court found it fit to keep equal custody all the way along until the start of school. We have problems with the exchanges. We have some unpleasant video of exchanges at the houses. Some of the problems have been father closing the door and then mom having to wait into the yard until the child comes back out. On August 2nd, Metro was called to mom's house. That was the event where she picked up the child. She drove across town, picked up the child at 5:30 rather than 6 o'clock, went to her house. Dad was at the house at 7:30 rather than 8 o'clock for the usual pickup time with the police present. And the police said, listen, we'll wait until 8 o'clock with the lights flashing. Mom said, no, we'll take the child out to the car. And within that half hour, the child walked crying to the car. These type of problems shouldn't be happening. And those are best solved with a third-party neutral location. Those could be, if you go with the week-on, week-off timeshare, that would be always at the school, and there would will be a trial long before we see another summer session. So if possible at daycare, at the school, or our preference would be the McDonald's at, I have the address written down someplace. I think it's 8556 Blue Diamond Road. That is the midpoint. The nice thing about the neutral location is it forces both parents to go at the same time, act civilly in a public place where there's cameras. If either parent's late, they can buy a hamburger or a soda for the child and keep the receipt, and it has the date and time stamp on it. And that's proof whether within the window of the exchange that's proper. We're already talking just in the, just this month, even last night, problems at the daycare with mom picking up the child. So the third-party location seems to be the least problematic of our options. I'm sorry, McDonald's 8556 Blue Diamond Road. The phone call issue. There used to be a phone call set up. Those were relieved in the second Missouri order. Mom's ability to contact the child over the last month has been one call for 6.5 minutes. We would ask for a nightly call or a couple of nights a week to the non-custodial parent, just a 15-minute window, 7 to 7:15. The child's 5 years old. If, sometimes that means 30 seconds on the phone for their attention span. Sometimes that means a couple of minutes. But these are not onerous requests for the non-custodial parent. For the school, mother informs me that father gave incorrect information to the school. She would like a standalone order for the school that just alerts them that she has the right to go into the school, to work with school administration, straighten out the records, and also to be on premises to visit with the child. This past week, mother had Thursday free for lunch. She went to the school to have lunch with the child, and she was rebuffed. She was informed that if the school had such an order, that they would permit it. Mother is under the impression that father gave instructions that mother is not permitted at the school.
Excuse me.
Father may have a different story on that. But we're not talking about an abusive, go every day time with the child. We're talking about a parent being able to just go to the schools, go to PTA meetings, take a look at the registration, to log in on school homework, to be able to go to Mother's Day, Father's Day, Grandparents' Day, those kind of things. In a high conflict situation, the school administration saying we need more clarifying orders, let's give them one. On the medical decisions, the Missouri court gave mother control over the teeth, and on the body and everything else over to father. I'm sure they have their reasons. It is, there were prior allegations of father saying that mother was taking the child too often for medical examinations. What I would like to do is what's referred to as the rule of three. I've used that in some of our other cases where either parent take whatever the medical treatment is, the child is taken in. If a parent disagrees, they can get a second opinion. If there's still a dispute, you get a third doctor calls it. That's what's proposed in our motion. We would like that as having more parity. The other problem is simply access to the records. For example, mothers had problems with the inhaler going back and forth between the houses and father keeping the prescription information. And he says, go get the information yourself. Well, if she's not the primary, if she's not permitted under the joint legal custody provisions to go into the doctor, she's going to get slammed at the door on that. So to make them equal on teeth and on body is where we would like to go. The name change, that's a simple one for us. We would just like the hyphen added to the last name. Mother believes that that was incorrectly left out in Missouri. The other side feels differently. And what we're seeing for school enrollments is just the initial of Bow being used. Mother would like the child to write her name as Bow-Baptista. Father has been sending the child around with a child tracker. The device itself is called a gizmo. Now, when I pulled this up on the internet, it looks like a GPS, like a Dick Tracy watch kind of thing, where communications can go back and forth. Mother is of the belief that that also permits a certain surrounding type of recording. Normally not a bad thing. In this case, that's invasive on mother's time. And that is coupled with the problem that we've had with phone calls, where mother does not want the phone calls between her and the child recorded. That says, I'm recording them anyway. Opposing counsel. Pardon me?
Is there an order for
recording? There is no order for that.
Okay.
And so we would like all recording to stop and that the calls go unmonitored. Now, I will say that what you're going to hear, if you haven't already read it, is that this allegation that the child has expressed suicidal ideations, mother has dealt with that. She doesn't think that it's of the same gravity as father. Father, I was just informed, has filed several CPS reports on it. CPS is still under their investigative phase. But absent some external proof, CPS is unlikely to do anything about it. This is where both parents having access to the doctors makes sense, where they could both work equally with treaters, and if there's a dispute about treatment, that they can take it to a second or third opinion. Ear piercing. Stepmother marked on the form that she was the parent of the child and had the child's ears pierced. I know it's a small thing, but that should never happen. So we need, in addition to our clarity on the joint legal custody provisions, either an admonishment or somewhere in the orders that mother be recognized as the mother and that stepmother is not included in the joint legal custody decisions of the child. Some of the other problems we've already addressed we can handle with our family wizard. The holidays in the Missouri order are scattered. They're not easy to read. We would prefer just the simple application of the court grid. That's very easy to read. We can slap it to the back of the order. And the mutual behavioral order, just the standard form. Department L has been circulating a larger mutual behavioral order. That's the language that we would like to use because it also includes social media. And I note on, we did not make it as an exhibit, but some of the social media has negative comments about mother. So that we have a Fund Me page for father's legal defense to pay for his attorney's bills where there's comments about mother. Those are not necessarily negative, but he talks about how he's trying to preserve his father's rights. And then on some of the Facebook pages, One of them, one is, can you believe that that my daughter has to wear a life vest in the pool? LOL, I grew up on an island. I knew how to swim by that age. I bet mother's going to make a problem out of that. That type of social media eventually, because it never disappears, will be read by the children. So within the mutual behavioral order, that would all be encapsulated and stopped. On the best interest of the child factors, we can address that at trial. For attorney's fees, court discretion. And I think what I have on page 2 and page 3, and I printed them out separately in case you wanted them, these are all of the detailed findings. I just broke it down. Find that the parties, everybody resides in Nevada, not Missouri, that the jurisdiction is here. These findings and orders are broken down. That may be a convenient way when you're ruling today. If there's any of these that you want to check off that we can cut and paste into an order, I'm glad to do so. If you want an extra copy, I have it here. If not, I will sit down and shut up.
Okay, it's an extra copy of what? Your
Page
motion?
2 and page 3 of the motion. It's just the relief and nothing more as a checklist. If you want that, I'll hand it to you.
That's fine.
Okay.
Thank you. Is that fine with you?
That's fine.
Okay.
Thanks. And that's just for reference,
No
not
problem.
intended as a persuasive moment.
Understood.
Thanks, Ryan.
All right, thank you.
Okay, so obviously we have a number of very contentious issues to address. I'd like to start with what I think is the most important of them, which are the suicidal ideations that have been expressed by the child. Now, some of these statements that were made to third parties and so forth of a language that a 5-year-old typically doesn't use. Such things as, I'm not emotionally equipped for this, and things that just are not part of a 5-year-old vocabulary. So the concern is that she is hearing things during visitations with mom that she is then parroting and repeating and perhaps internalizing. A therapist has been contacted. Emma has had an appointment with her. The therapist's information was given to plaintiff. Additionally, the therapist encouraged, as does Dad, Mom's involvement in the therapy to sort of get to the root of the issues and hopefully resolve them. Because Dad was so concerned about these statements, he, as soon as he became aware of this issue, notified Mom. Mom sort of brushed it off like it's no big deal. Dad contacted CPS and made a report that is, as counsel indicated, still under review at this point. Basically, the indication was, well, if we don't have any evidence of physical abuse, there's not a lot we can do. It's going to go to a supervisor for review and further investigation. So Dad, being proactive, got Emma into therapy and has, of course, as I mentioned, given that information to Mom. Now, the sort of ongoing issues in the legal custody aspects with respect to the medical decisions and dental decisions, that was done for very specific reasons in Missouri. And as counsel alluded to, there were issues where Mom was using doctor's appointments in an abusive manner to try to establish a case against Dad, even going so far as requiring a 3-year-old child to submit to a rape examination, alleging sexual abuse against Dad. Now, the reason that that order is in place is that the court in Missouri wanted to prevent those things from continuing to happen. The only reason that the dental side of it was given to plaintiff is because she's a dental hygienist. So the court felt that she had specific expertise and knowledge to be able to make the best decisions in that capacity and didn't feel like that would be something that would be able to be used as abusive allegations against Dad. So that it is an unusual order, and we don't dispute that, but there were solid reasons for putting that in place, and we feel that it's appropriate to keep that as it is. Now, with respect to the inhaler issue that was mentioned, continuing to kind of get these medical issues out of the way first, it was actually Mom that kept the inhaler and said, oh, get it yourself, leading to a situation where this actually occurred, I believe, over a holiday weekend, where it was impossible to get the information from the doctor. And the issue was that in order for the daycare to administer the inhaler if needed, they had to have the prescription, which is on the box or whatever. and she refused to provide that. So Dad had to go to the pharmacy, get a refill on it, in order to make sure that the daycare had it in the event that Emma would need it. So and there are documents that will support these contentions from Dad. He has messages back and forth with plaintiff that demonstrate exactly that it was her withholding this information. With respect to the ear piercing, Mom and her mother had wanted to take Emma on a number of occasions. Emma didn't want to do it and asked that she be able to do it on Dad's time. And Dad said, well, I don't see why not, since your mom already had agreed to do this in the past anyway. So I don't think there was any real issue with her actually getting her ears pierced. I think it's more that Mom harbors a lot of animosity for some unknown reason towards stepmom. And truthfully, stepmom encourages interactions between Emma and Mom. She never holds herself out to be the mother of this child. She, in my personal opinion, seems to have a very good understanding of what her role is and doesn't overstep those bounds. Now, in respect to the schooling issue with the daycare removal and all of that, basically the allegation here is that she wasn't able to pick up from daycare and, cause this whole scene and all of that. The issue is that Mom shows up early in violation of the time frame set in the court order and tries to take Emma out of daycare without even signing her out, which as far as the daycare is concerned is kidnapping the child. So it's her trying to circumvent the policies of the daycare facility that led to the issue. It was nothing that Mr. Baptista did. He wasn't even present when this occurred. So a lot of these problems, I think it's very clear that Mom creates herself and brings upon herself. She tries to make things far more contentious than they need to be. The issue with respect to her trying to attend school and have lunch with Emma, again, was her own doing. She is listed as the mother of the child on the school records, and we can provide that documentation to the court. The issue was not that she wasn't permitted or that Dad somehow prevented her from attending the school or having access to records or any of that. The issue was that she didn't call the school ahead of time and try to make arrangements. She just showed up and said, I want to have lunch with my daughter, and they said that's not our policy and turned her away. So, Mom needs to learn to follow the rules, and that's been the issue all along, is that she doesn't think she has to abide by the court orders. She doesn't think she has to follow the rules at daycare. She doesn't think she has to follow the rules at school. This is the overarching theme that this case has endured from its outset in Missouri. Now, with respect to the timing of exchanges and so forth, first of all, because of the situation with the suicidal ideations and engaging in therapy services and so forth for that, we feel that a change in custody to a week-on, week-off schedule definitely would not be appropriate. The court in Missouri obviously fully considered the circumstances in whether these parents would relocate and so forth, and provided for that in the order. Now, the reason that Mr. Baptista was given that primary custodial time during the school year is because the court recognized him as the party to be able to give the stability and schedule and things that Emma would need starting kindergarten.
Was that in their order?
I believe there was some documentation. I don't have reference to this specific language.
Okay.
But I certainly would be happy to go back through the order and provide that to the court if necessary. Now, with respect to the, I'm sorry, let me back up 1 second. So we don't feel it would be appropriate to make that change, and if anything, it would be more appropriate to ensure that visitation is supervised given these suicidal expressions made by the child, until such time as the therapist can more fully get into this with her, and hopefully Mom can be involved with that and resolve the issue so that Emma isn't saying these things anymore or feeling these things.
So I just want to be clear. You're requesting supervised visitation for Mom. Why exactly?
The concern that has been expressed is that Emma is hearing these things and internalizing them while in Mom's care. And the therapist has made some indications to that respect. Obviously, it's more of a trial issue, and I fully understand that, but the concern is for protection of the child at this point.
Who's the therapist?
Do you have her? I'm sorry, I don't have it handy. We do have her card, though, at least in picture form.
Oh, that's picture from you.
Oh, do you have the actual card?
It's Jackie Harris. Let me get the.
Jackie Harris?
Yes.
And how long has she been seeing the child?
She went. Oh, I'm sorry. She went once or twice. We went for one time, and then she went with us and to one of the.
So when did she have her 2 visits? Just recently?
The last one was this past Thursday, and the time before that, Emma actually wasn't there. It was just us.
Who's us?
Me and my wife.
What about Mom?
We sent her the information, and Jackie said she never contacted her.
Mother attempted. She is not connected with the counselor.
Okay.
The child does have another appointment set up for Thursday next week as
September
well.
7th.
Okay.
Yeah, Jacqueline Harris, MA, is the therapist. And this photo here is actually from a text that was sent to Mom so that she would have the therapist's information. So, yeah, the concern is that these things are coming from Mom's house. And, we want to be sure that this child is safe and that she doesn't act out on any of the things that she's said. Now, with respect to the exchange issue, in terms of custody, should the schedule as it is remain in place, we indicated this in the opposition that what we would recommend is instituting the honk and seatbelt rule so that these two aren't even interacting. They just watch Emma, walk from the door to the car and vice versa. I think Mom has indicated that it would be impractical because she lives in an apartment. But Dad has said that there's a garage right there that he can pull up in front of. She can open the garage door, let Emma walk out, get to the car. She can open the car door and buckle herself. That's not an issue. It's not a far distance. It's not like she'd be crossing a road by herself or anything of that nature. So I think that would eliminate a lot of the tension. Having exchanges happen at the daycare or at school based on the schedule as it is now just is impractical, simply because those exchanges happen at 6 p.m., most of the time, Emma's not at the daycare at the time that the exchange would happen, so it would require going to the daycare specifically to make this occur, or driving to the school, which just doesn't make sense at 6 p.m. With respect to the phone call issues, the current order, which was the amended order from the Missouri court, had eliminated the phone call schedule because it was abusive. It was constant calls during Dad's time. And the records that plaintiff is referring to in terms of all these calls she's made in the last few weeks and hasn't been able to speak to Emma, she's calling Dad's phone on FaceTime when he's at work and Emma isn't there. He can't even answer the phone or have it on him while he's at work because he works in security and they're not permitted to have them on them. So she's intentionally calling to try to create some record for the court that, oh, he's preventing me access, when that just isn't reality. And we do have phone records and documentation to support those allegations as well. The GPS watch, it's not some sort of eavesdropping device. I'm sure Your Honor's probably seen advertisements for these things. It's basically a GPS tracker, which frankly I think is a great idea for a little kid who doesn't really need a cell phone at 5 years old. It does have the ability to make phone calls from it, but there's no independent ability to listen in on surroundings on this thing. It just doesn't work that way. It's not in its features or capability. And that's something that Dad certainly wouldn't be attempting to do. With respect to the phone calls in general, though, and the recordings, the Missouri court looked at a lot of recordings in the process of the evidentiary hearing in that matter. And, Mr. Baptista has never recorded a call without Ms. Bow's knowledge. He has always said, hey, I'm recording this call. She could have hung up at any time if she didn't want to participate in a recorded call. Given the circumstances with the child's mentioning these suicidal ideations, I think it would be preferable to have an order of the court allowing recordings to make sure that nothing inappropriate is being said to Emma to encourage these thoughts and internalized feelings. So we would request that that be an order of this court. We do agree that our family wizard should be implemented and that hopefully would eliminate some of the conflict and contention as well. See if I missed anything else here. Oh, the the name change issue. So this child has already had her name changed once as a result of the Missouri order. This issue was brought back to the judge in Missouri, and it's been addressed ad nauseum there. The judge there indicated if I had intended for the name to be hyphenated, that would have been the order. Now she thinks she can just get a new bite at the apple because we're in a new court.
Where did you see that? Was that in writing?
I believe that was a statement made at the hearing. Certainly we could obtain the videos and such from the hearing if necessary. But it has been addressed more than once in Missouri is the point. And the order stood as it was, that the name is Emma Lee Baptista with no hyphen. And there's no reason to put this child through changing her name again. We're talking about a hyphen. It's absurd. You know, she can use her full name. That's totally fine. But the name should stay as it is. I believe that is everything. I've worn myself out talking, and probably you as well, so I apologize for that. But I'm certainly happy to address any questions that the court may have as well.
Okay, thank you.
Just a few comments back on the what's being requested for supervised visitation is one time with an LCSW to make an assessment of whether the child's suicidal or not. CPS has not acted timely. Mother has not been a part of those conversations. However, we do acknowledge that conversations have gone back and forth. For example, Mom, if I didn't exist, would you and Dad fight less? We have a child in a high conflict situation that's blaming herself. Mom's giving her age-appropriate comments. You just need to play. You need to just love both parents and move on. Don't worry so much about us. We have a child that probably needs some counseling, but this is not a child that's going to run out into the street to kill herself. This is a child under constant stress. And that's exacerbated by the recording of the phone calls when the child's on the phone with the mom. That's exacerbated by a GPS tracker. We don't want you to ever get kidnapped. All of these things add to the anxiety of the child. And that's what mother recognizes as what's going on with the child. And let's talk about the timing of this. These people have had an equal timeshare up until about 2 weeks ago. So now the appointments for the suicidal ideations do not take place until Dad has the child almost under his complete control and certainly under his sole medical control. So all of this is colored in a way that does not ring true to our side of the case, although we do not oppose therapy. The child was in play therapy in Missouri, and Father ended that therapy previously. He now wants to resume it. We don't have a problem with it, but let's not make it bigger than it is. This is a child under pressure that has not been diagnosed by a pediatrician, that has not been acted upon by law enforcement, and has seen the LCSW just one time for one appointment. On the medical decision making, and this is where the rule of three really would come to full fruition. The to bear out this argument a little bit more, Dad says the child's suicidal. Mom says, I don't think so. Let's get the second opinion. They could, in this instance, although they are not equivalent, you could go from an LCSW to the pediatrician. If the pediatrician then says no problem, Dad says no, I still think there is a problem, they could bring in a third doctor. And that's the tiering that would happen rather than in the middle of a custody dispute, just while the motion was already pending with this court, to then awaken and say, oh, now it's time to get some therapy. On the inhaler, we have the opposite story to tell. So we have that will bear itself out at trial, but either way, we have parents that are fighting over prescription information. If they are both equal in the medical decision making, then they will each have equal access to the doctors and the department stores. On the ear piercing, stepmother encourages mom. She never identifies herself as a parent. Here is the release for the ear piercing where she marks herself as the parent. And here is a picture of the gizmo device with Emmeline phone number listed as mom, and my client is not listed at all on the device. So I appreciate counsel is saying what her client is telling her, and I'm telling you I've got pictures and proof that are different. On the schooling and the daycare, we have a dad that has, Metro's been called, mom's been stopped at the daycare. All of these are mom's problems, no problem by dad, even though it's the daycare at dad, and he's the one that ultimately controls the authorization for access at the daycare. If we go back to the neutral location that we have proposed, exchanges at school, if you do the every other week visitation, or a neutral location that's equally inconvenient to both people, they're going to have fewer problems. On the exchanges, the honk and seatbelt rule, what they're talking about is at Dad's house, which is already documented to be a problem area, and then a honk and seatbelt rule at Mom's apartment complex. I don't know if you've ever lived in an apartment complex. I certainly have. If somebody was honking the horn out front, I would never hear. On the phone calls, we're just asking for 15 minutes a night, a couple of times a week. On the recording, there's no orders from any court permitting the recording. Missouri might have permitted it during that part of the litigation. I don't know for certain. But here in Nevada, we have criminal statutes that prevent that. And the last on the school, whether Dad would be a better school provider. I've just went through about 35 pages of the order. I can't find any statement to that effect.
To what effect?
To the effect that Dad would be the steadier person for providing school. I believe that the residential on the school was based solely on the fact that Dad was, the initial large order is that Dad was in Las Vegas, Mom was in Joplin, Missouri at the time, or somewhere in that general area, and that it was equal timeshare all the way until school begins, and then start primary care when school starts, because that would have been the practicalities of a long-distance relationship. That's not lessened by the 250-mile rule that is deeply flawed. I think had the court, which you do, have the facts that they live very close to each other and that they've been on joint physical custody this whole time, the week on, week off with exchanges at the school gets the police out of the business, gets the daycare out of the business, and gets that child back to the stability that she has known her whole life and equal sharing between the parents. Thanks.
Okay. So I just want to be sure I understand the situation. So when the Missouri court held the trial, Dad lived here.
Correct.
So he lived here the entire time.
Correct, Your Honor.
So nobody moved from Missouri to here.
No, and in
Dad,
fact,
except Mom.
Correct,
Okay.
correct. And in fact, he was actually driving 22 hours to Missouri to have 1-hour visitations with Emma at the initial outset of that case.
Okay.
So that was contemplated from the very beginning. And just to the point of, this issue of naming one of them as primary, given that one was living in Missouri and one was living here, if the court felt it was appropriate, that could have been Mom that was named as the primary custodian during the school year. So I think that argument fails on its face that, the court found that these parents were equal, when in reality they're looking at this and saying, we feel that this would be the parent best suited in the best interest of the child to have primary custody during the school year.
Okay.
There were a couple factual issues that I'd like to address, if I could, just with respect to a few things that were raised on counsel's rebuttal argument. Just to clarify the circumstances, the suicidal statements actually began at a time when there was a week-on, week-off schedule. We do have text messages and documentation to show that. The only reason Emma has not had counseling sooner was that there weren't appointments available, and they got her in basically as quickly as they could with a reasonable therapist. The statements that, this isn't a child who's in danger of running into traffic, I mean, frankly, to my knowledge, counsel is not a child psychologist and has no basis for claiming that to be the case. I think out of an abundance of caution, it's important not to play games with this child's life and to make sure that she is in a good and safe environment. The counseling that was going on in Missouri, that didn't end at Dad's direction either. That was part of the Missouri order. So that wasn't Dad saying, nope, I'm taking her out, I'm not going to do this anymore. And then finally, with respect to the photo shown there, I haven't seen that before, but as best I can tell and from what my client can see, that's actually some sort of medical bracelet or something. It's not the GPS watch thing that we've been talking about. And then finally, the allegations and arguments made as to the honk and seatbelt issue. He's saying if you were in an apartment, you wouldn't even hear it honking. Well, she knows when the pickup's going to be, so she can also be, checking out the window to see if he's there yet. I mean, this is not like it's some major issue where she can't see, from her home when he's there. And frankly, it would eliminate these two having to interact and would probably help a lot with the level of conflict. Thank you.
Okay, so
Please submit, Your Honor.
I have a couple questions.
Yes.
So the order from Missouri said that they were supposed to go to co-parenting sessions with Dr. Webster. Did they do that?
Yes.
They did, Your Honor, yes.
How many times?
I think we had 3 or 4 sessions. I did mine over. I'm sorry.
3 or 4 sessions?
3 or 4 sessions. I did mine over Skype because it was in Missouri.
Okay. So did Dr. Webster tell you you were done after 3 or 4 sessions?
He said that the amount of dispute wouldn't allow us to have a proper. He wouldn't be able to do a proper finding, and she had already intended to appeal the final judgment. So there was that, and he just wasn't going to get involved any further.
Is that about right?
No, actually, we ended it because Father said it was not financially obtainable for him, and Webster said that we needed to do something in person with someone that could be in the room with us where we could hash stuff out because Skype was
Okay. And are the allegations, I guess I'm asking counsel, are the allegations of them not treating each other well still continuing to this day?
Yes, the language that I quoted in the
On both
reply
sides,
was
right?
Okay,
from
I'm just saying,
August
treating
15th.
each other, I said.
Yes.
So it's still continuing.
Very hot, very hot.
All right. Okay. My other question, let's see. Well, it's quite a detailed order from the other court. And now I have a pretty good idea of what happened. So everything I do today is going to be temporary, so we need to set a trial date. How quickly can you be ready? Because I think we have a November date, otherwise we're probably looking at January.
As long as it's not early November, I believe I'm open.
Because I don't know how much discovery you need, or...
I know we are going to need some time to get some documents and things from Missouri, so that may take a bit longer than a November setting.
We don't think that this is a paper-heavy situation. It's already been litigated, and we wouldn't want to relitigate what's already been found by the Missouri court. What's on the ground is what's happened since October 2016 forward, which is paper light, so to speak.
So this would give you over 60 days. Is that enough time?
I think we may need closer to 90, Your Honor, just to be safe. I don't want to be in a
What
situation
is
where,
90? Is
you know,
that the
at
end of
last
November?
minute.
I think I might have, or did I give that away? Hold on. Let me look. I gave my date away. And I'm assuming we need a full day,
Yes, Your Honor.
if not more.
Right.
Do you think we need more?
No.
Just one?
In fact, I'm more inclined to go a half day because I think...
Really?
Yeah, because I think this is more the testimony of the parents and not a paper-heavy custody matter. But if the
Okay.
other side says they want a full day,
I'll be honest, I don't think there's any way to accomplish it in a half day.
I don't
think
either,
we may
just
be
from the
pushing it at
motion
one.
calendar
Right.
so far.
Right.
I don't think, 'cause yeah, I don't think that's feasible. I thought we had something, all right, so November's too early?
I think so, Your Honor, just to be on the
November's good
safe
for
side.
us, but
You want 90 days for discovery?
Right.
Goodness.
these should all be easily obtainable documents by Father's former counsel. We're not dredging from the ground up on this thing.
Well, we may also have some additional documents from here from the therapist and so forth, the documentation from CPS. I know sometimes getting reports from them can take some time. That's my concern. I don't think it's going to be a lot of things. I'm just concerned about the amount of time it takes to get the things that are needed.
We would ask for 60 days, but court's discretion.
Okay.
And it's not my intention to drag this out by any means. I just don't want to be without things that we would need to present to the court.
Well, no, it's just that we had something open up because right now, full days are in January. That's why I was trying to. Oh, you gave away the last one. Okay. I didn't know that. So I'm trying to see. Maybe we could do 2 half days. Would you? See, I don't want to go too long. Okay. What if we do 2 half days in December, and then you're saying it's only going to be a half day?
I
We
think
could
I
do
can
2
move pretty
consecutive?
quickly.
I think that would work.
Or you know what we could do? What day are you looking at? 11/22? Okay, we'll do that.
Okay, so it'd be December 21st at 1:30 and the 22nd at 9 a.m.
Okay,
All right, so
we're
Discovery's
good with that.
open. When do you want to, I'm sorry?
I'm very good with those dates, Robert.
Okay. Well, Discovery's open. When do you want it to close?
We had discussed, counsel and I, 30 days prior.
Just as a knee-jerk reaction, but
I would prefer, if possible, maybe 15 days, just in the event that it takes longer than anticipated to get.
let me ask this: are we talking about bringing in any experts?
The only one I would anticipate is the therapist.
Well, that would be a treater, not an
Right,
expert.
not an expert.
So yeah, as long as we're not dealing with an expert.
No,
report, I'm
no, I
fine
don't.
with 15
I don't
days.
anticipate that at all.
Okay, so what would 15 days?
December 6th?
So it'll close December 6th. Exhibits and pretrial memos would be due
12/14?
on December 14th. And when do you want to exchange your initial witness list?
End of September.
Yeah, I think that's reasonable.
Okay. So is the last day of September a weekday?
The
So it'll be the
last
29th?
working day would be the 29th.
All right, so that'll be due the 29th. Okay. Did I leave anything out?
I don't think
That's
so.
pretty.
Okay.
That's pretty comprehensive.
All right, so we're set for the trial. So this is a very unique situation. Some of these issues I'll be deferring to trial. The real issue right now is figuring out what's in the child's best interest on a temporary basis. I'm going to order the CPS records. Of course, you can get them yourselves. I can't give them to you to have. You'll read them. Now,
We're comfortable if that's an in-chambers review, and if you
It
need
is.
us to look at it, you can.
but I'm
call us.
saying as parents, you
Ah.
can get your own copies. I'm just saying I can't give you the paper copies. That's just the way the rules are written.
Right.
But you can always get them. And if you absolutely need them, I think you can do a motion to ask for them to be released to you. And I can grant that. So right now, the request for supervision, I don't think I have enough legally to grant that. First of all, Mom hasn't even seen Miss Harris. Only stepmom and dad. And of course, they told their version of the story to her, to the therapist. And then there's only been one meeting. There's really no proven nexus between mom and the allegations that the child's talking with suicidal ideations. So I have to deny the request for supervised visitation. The tricky part about custody is looking at this order, because I think Missouri might use some legal terms a little differently than we do. So the court noted that both parents have a bond. The court said the child's done well in spite of the parties' continued bickering and unwillingness to cooperate with one another or to co-parent with one another. And then the court ordered that counseling. I can tell you now, you have a 5-year-old in therapy, and we're using the words suicidal ideation. Your child is very aware of how you two are dealing with each other, and it's very disturbing. So I think it's more than reasonable to have you both go to the cooperative parenting class at UNLV. I don't know what's going to get your attention. Like, your child's soaking this up. You're the adults. You can't treat each other that way. You can think whatever you want. You can go vent to your friends and family, but you don't treat each other like that, and you certainly don't do it in front of your child. So, I mean, by all accounts, a 5-year-old should not be in therapy. It's very, very, very sad, and we need to take a new route. So I'm going to start right off the bat with the cooperative parenting class. Let's see. I mean, just some of the language that's in this order is just, it really gets your attention. At least it gets my attention. The court says, each of them profess great love for their daughter, but the parents' relationship has been more on the order of military exercises of opposing parties rather than a heart beating as one. I thought this was eloquent. The parents should understand that the one heart beating is that of their daughter, and the conflict between the parents needs to be dramatically reduced, and the time spent thinking of things that will be in their daughter's best interest. So, I mean, you two have already been on notice of this, of your behaviors, and from all accounts, it hasn't stopped. And I can just tell you that can't be tolerated here. It has to stop. Let's see. There's quite a few pages I'm going through. All right. Regarding the medical, regarding medical, I'm not going to change that today. That'll be a trial issue because the court made very specific findings of why they ordered that. So I certainly don't know enough today to make that change. That wouldn't be appropriate without testimony and evidence. Okay, and then you want a behavioral order. You agree to that, right?
Right.
So you'll agree to the language in it?
I don't recall the specific language that was provided, but if I
But you'll get
remember, it
together
was
with each other?
Yeah, that's fine.
And
I think it
agree
was
to one?
pretty
Okay.
standard.
Because I know the allegation was made about social media. I will note that apparently both have done this
Correct, Your Honor.
in the past, at least according to the Missouri order. They've both gone on social media with derogatory statements. It's a very long order. I'm looking for the, oh my goodness. Okay, so here's the order says the parties are hereby awarded joint legal and joint physical custody of the minor child with dad's address designated as the address of the child for education and mailing purposes. So that's not normally language you use here. So I think you each have a good legal argument as far as mom's position that really it's joint custody and they've been sharing 50-50. Nevada is a joint custody state. I mean, you put all that together, and I can understand the request for week on, week off. I can understand Dad's position because in reality, even though it says joint custody, really what the order contemplated with Mom living in another state was that Dad was the one that had what we would call primary custody. However, the circumstances have changed. Mom is now living here. So,
And, Your Honor, that
Yes.
was contemplated in the order as well.
well,
mentioned
they said
specifically.
within, 250 miles?
Yes, Your Honor.
I know, that's what I'm saying.
It is a
It's
bit
a
of a
little
strange
confusing.
order. Right.
I don't know if it's strange. It's just not what we're normally used
Right.
to reading and seeing, and I mean it's just different. That's all. So, and of course I don't know what that judge was thinking specifically regarding this. If they had known that Mom was going to move, in close proximity to Dad, what they would have ordered, I don't know. So, but I do know that. I was looking for the language, I had marked it, that the goal was that they would both spend, here we go. It is the intention that both mother and father shall foster and maintain a co-parenting relationship. But there was language that they wanted them to both spend time with the child. I think it's almost 40 pages. This order. That's why it's taking
Yeah,
me so
it's
long.
36
Sorry, I
pages.
don't talk this slowly usually, but I'm trying to find what I'm looking for.
And no page numbering thing through.
There's no page numbers. That's true.
Yeah, I went through and numbered mine to make it a little easier.
All right. So, yeah, you have a very unique legal situation, and you both have good arguments on either side. So I have to just figure out temporarily what I think is in the child's best interest. Again, I'm denying the request for supervision. You both had to be involved in the therapy. If Mom wants a second opinion, I'm not sure a pediatrician is going to feel qualified to do that, but they might give a referral to who they would go to. So you both, I don't know exactly, I haven't read through the whole medical issue, but if you make an appointment for the child, you both need to be able to go to the appointment. I mean, that's just in your child's best interest because you both need to know what's happening with her. All right, so I'm going to leave the visitation to the end, and I will go through, I'll use your checklist. Okay, so we all agree that Nevada has jurisdiction now because everyone lives here. You both agree that we needed to set an evidentiary hearing on custody. We've done that. The legal custody, I'm deferring until trial because I need evidence on that. The exchanges, well, let's leave the exchanges until we do the timeshare. You're going to agree on the language for the mutual behavior order, right?
Correct.
Okay.
That's right.
Okay, and then the name, modifying the name with the hyphen. I just need some proof because Dad's counsel said that the other court made it very clear that they had already addressed that and that was what they intended. So if you can get that information, we can defer that issue to the time of
Great.
trial. So I'm not changing the name today. So again, this is a tough one, and again, my order is only temporary without prejudice. I really don't know how we're supposed to look at it legally, because technically it's a modification, but also they say they have joint custody and tried to give equal time, this month on, month off. So I'm going to do what we would normally do in Nevada, which is I don't have any reason that you wouldn't share joint legal and joint physical custody temporarily. I think given the high conflict, week on, week off is best. And the least amount of exchanges between the parents right now, at least until they go to the cooperative parenting class and get past these differences that they have, the exchanges should be at school. What do we do if school's not in session? Then I think we need a public place. And did you have any objection to that McDonald's they suggested? I don't know where you guys
We
live.
tried to pick a midpoint.
It's like right in between us.
Other than it does mean not good. She starts making her comments and I disprove what she says because there's no
That's fine, Your Honor.
Okay, so that's the one on Blue Diamond you said? Everybody knows where that is? Okay.
And we'll make that at the same time as school, so it's always the same.
Okay, so with that, today is Thursday, tomorrow is Friday, so are we gonna have, do you wanna pick up after school on Friday and then drop off that Friday morning, the next Friday morning, and then the next parent will pick up after school Friday?
Friday morning, yeah, we're good
Either
with
or
that.
is fine.
Which would you prefer?
Friday may be easier only for this in that as we roll forward, we're more prone to Monday holidays in Nevada than Friday holidays. So,
Probably true.
so we're probably on a
So
more
Friday
steady
after
track.
school, so who wants to have the first week? Who wants to do the pickup? Start tomorrow.
Dad has had the child for 2 weeks. We would propose that we take this one.
Okay, and do you have any strenuous objection to that?
Your Honor, the question is as to the holiday schedule as well. I know we have a holiday coming up this weekend.
Oh, that's right.
Right.
But if you do week on, week off, we're just gonna, let's see. The only one that would really come up is Thanksgiving.
Well,
3 days, 3
not
days,
exactly.
I'm not
We've
gonna worry
got-
about
so We've
that.
got Labor Day, we've got Halloween,
But I'm not gonna worry
Nevada
about
Day.
3 days.
We've got, we've got several coming up is the only concern.
We don't have several. We have Labor Day and Halloween.
Halloween, Nevada Day, Veterans Day. There's a lot
Those
that
are all,
happens
but
at the end
those
of the
are,
year.
but there's not really that much school that's off. I looked at the calendar. The only one that's a block of time is going to be Thanksgiving.
Right.
So,
And whoever gets Thanksgiving, the other person gets Christmas, and we'll just start the rotation.
Yeah, I see whoever has
And-
all
well,
that.
how
Court's
do you want to
discretion.
alternate the holidays?
I'm,
Because you're going to have those two holidays. No, Christmas is coming up right after the trial.
Right.
But, so we really just have to talk about Thanksgiving. I'm not going to worry about the 3-day holidays. They're going to fall where they fall.
Hmm?
Whoever has her that week has the holiday.
we're fine just alternating weeks with no respect to,
Whoever has
Well, I doubt,
with no
But
difference
if
for
it's-
the holidays. But what we can
I
do
have a feeling
is,
the other side isn't.
No.
Can't believe
You don't want to miss Thanksgiving.
neither one of us went.
Thanksgiving is, it's a full week.
It's a
in
full
front.
week off of school now, because she's in kindergarten, right?
Didn't have her last
Is she in
Thanksgiving.
daycare or kindergarten?
In kindergarten.
Okay, that's okay.
So what we can do is, whoever gets Thanksgiving gets the front end of Christmas, and that,
I don't think
That-
that would be reasonable. That would cover Christmas Day and Thanksgiving for the same parent.
no,
No,
whoever
he's
gets
saying,
Thanksgiving, the other person
say
gets.
mom got Thanksgiving,
Oh, the other
then
person
dad would
would
get the week with the Christmas Day,
Sorry if I wasn't
is what you
Yeah,
were
no,
saying,
I
right?
heard that the opposite way, so yeah.
Either was fine.
And I don't know how it would rotate.
Okay, so which one does dad want? And we can just make sure we work out the weeks that way.
Christmas, Your Honor.
All right. So then go through, you'll have to look at the calendar
Yeah.
and figure out where
Well,
that takes
I'll work it
us.
out with council and we'll
Okay.
put that into the order and mark out the full school week.
And that actually works, because Christmas is Monday, so school gets out that Friday.
Right.
Perfect.
So just make it that that's dad's week this year, and then make sure that mom gets the Thanksgiving. And then
Yes, Ron.
try to do it evenly.
And other
we'll
than that,
have-
we
so
won't put
Mom-
anything else in. We'll just keep it as trim as possible for you.
Okay. And then, so I'll grant Mom's request that she starts this week. And then Dad has that Christmas Day week. All right, and we have everything set there. In Nevada, unless you have a court order, you're not allowed to record phone calls. So that we're not recording phone calls. I don't see a reason for that. The gizmo, if Mom doesn't want her to wear it when she's on Mom's time, I don't see what the issue is. So just take it off, right? I talked about the name. We're going to defer that. I just said I'd order the CPS records. Did I leave anything out?
You know, you've covered the most important things, and we can defer everything else down the road.
I'm not sure what I left out then. Okay, so I know that you'll try to settle. If you can't, we have those dates set aside. And then Mom and Dad are ordered to take the next available class for the UNLV Cooperative Parenting. I think that might go a long way.
It's a good course.
It is. A lot of people have said that they've gained some good insight from it. I hope that it helps you. But I can't imagine having my 5-year-old in therapy and that not getting my attention. You have to really just try to be kinder with each other. I'm sorry, what? Oh, for mediation? Yeah, we can do a separate. Do you want to do a separate return for mediation just in case?
I
Yes,
think we should.
Okay.
because if we find a sweet spot, given what you've advised today, we might be able to pull things together.
Okay. What's,
November 15th at 11.
okay. All right, so make sure you take the class. Good luck in mediation. And counsel, you'll prepare that order and we'll sign
I'll
off
prepare
on
for
it.
counter
So you
signature,
have
Your
the
Honor.
agreed upon language and dates and everything. Okay.
Of course.
All right, thank you. We're adjourned.
Thank you
you,
very
Honor.
much for your time today.